Have you ever wondered why, in a civil lawsuit, the person who is being sued gets to make closing arguments first? Would you like to learn why? Come join me as I share with you this great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury trial lawyer practicing law here in the state of New York. So here's what happens. When someone brings a lawsuit seeking compensation, seeking money for the harms and losses that they suffered because of someone else's carelessness, either in an accident case or in a medical malpractice case or even in a wrongful death case, the person who brings the lawsuit has an obligation to prove the case to the jury. We have to show that we are more likely right than wrong. And it's our job to do that. And that means we get to go first at the very beginning of the trial. We have to show to the jury that we are more likely right than wrong, that the person that you are suing or the company was wrong and they did something careless that ultimately caused you injury and harm. The person who is being sued then has an opportunity to rebut those arguments. Now, at the very end of the trial, as we're getting close to making closing remarks or closing arguments, also known as summations, the attorney who is defending the case is the one who gets to make those closing arguments to the jury first. And the reason that's done is because it allows the person who's bringing the lawsuit to literally have the last word. So that now it's the defense attorney who gets up to talk to the jury first during closing remarks. So now he will have an opportunity to explain to the jury what he believes the facts of the case were and what conclusions the jury should reach on behalf of the defense. After the defense is done, I will then have an opportunity on behalf of the injured victim to actually get up in front of the jury and make my closing remarks next. I literally have the last word in terms of the attorneys who now get to speak to the jury at the end of the trial. Ultimately, the judge has the last word. But the reason that we go last is so that now we have the last opportunity to explain to the jury why they should award a verdict in our favor and not on behalf of the defendant. So why do I share this tidbit of trial trivia with you? I share it with you just to give you an insight and an understanding to what goes on during the litigation process, during the trial process here in the state of New York. You know, in all likelihood, you have questions or concerns about what will happen if you go ahead and bring a lawsuit and now your case goes all the way to trial. Well, if you have legal questions about your particular matter and your matter happened here in New York, what I encourage you to do is pick up the phone and call me. I can answer your legal questions. This is something I do every single day and I welcome your call. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's quick video. I'm Gerry Oginski. Have a wonderful day.